Welcome everybody to this fifth lecture from the Constitutional Imaginaries lecture series. My name is Martin Belov, and I'm professor in Constitutional and Comparative Constitutional Law at the University of Sofia and Kliment Ohridsky Faculty of Law, but I also teach a lot abroad, and I'm also the leader of that strand of the project, which is called Summit EU VASC, which means European Values and Social Challenges. We are very grateful to the European Union, Bulgarian Ministry of Education for granting us this project, through which we organize several types of events. We organized 3 big conferences as part of my strand. The first one was on the representative democracy in crisis, and it happened in the spring of 2024. Then the last one was in November, on 9th of November, and it was devoted to a very interesting topic, I would say, not because I'm the organizer, but because I think it's both topical and fascinating. And the topic was legal imaginaries of crisis and fear, with some brilliant scholars from all over the world. And now there will be a third conference in which our distinguished guest this evening, Professor Cosmin Cercel, will also participate. It will be devoted to emergency constitutionalism and constitutional polycrisis, and it will take place in April 2025. So these 3 conferences are just a part of our job here as part of this project. Then we have also I'm organizing also 2 lecture series. The first one is devoted to constitutional emergencies and emergency constitutionalism, and there we had already 2 or 3 lectures, and this is actually the 5th lecture of the second lecture series devoted to constitutional imaginaries. Previously, we were delighted to have, as part of these lecture series, Maja Sahajic from the University of Utrecht, Netherlands, Professor Francesco Palermo from EURAC Bolzano and the University of Verona, Dr. Miroslav Sadowski from the University of Strathclyde, Dr. Uladislav Belavusau from the Acer Institute in The Hague. And now we have Professor Cosmin Cercel from the University of Ghent, Belgium. Just a short announcement, we'll have at least 3 more lectures from this lecture series in 2025. In February, we'll host Zoltan Sente from the European University Institute and some Hungarian universities. Then we'll have the Grand Master of Constitutional Imaginaries, Professor Erzsébet Siban, who was the head of the Institute for Social Legal Studies at the University of Cardiff, and currently he's judge at the Constitutional Court of the Czech Republic. And also we plan to have a lecture of Petr Aga from the Charles University in Prague. So having said that, maybe I have to say a few words about today's lecture. The topic of today's lecture is Archiving Crisis, Emergency Law and Constitutional History. And we have both the pleasure and honor of having with us Professor Cosmin Cercel, who is currently teaching at the University of Ghent, Belgium, where he leads also an important European Research Council project called Emerge. So Cosmin is investigating the history of emergencies across Europe during the 20th century, and he focuses on the genealogies of law and politics with specific reference to 20th century continental legal history. He's author of many books, just to mention a few of them, Towards the Jurisprudence of State Communism, Law and the Failure of Revolution. Then there was another book on States of Exception, Law, History and Theory. Also, he's co-editor of the book Law, Populism and the Political in Central and Eastern Europe, Law, Culture and Identity in Central and Eastern Europe, a Comparative Engagement. And he has also many fascinating publications, including publications having these fancy topics such as Darker Legacies of Anti-Corruption, Fascist Claims to Sovereign Power, and so on and so forth. So today, I believe that Cosmin will deal with first the theory of constitutional emergencies in historical perspective. Then he will make an outline of the most important strands of history of that phenomenon throughout the 20th century. And probably he will tell us what happens nowadays in times of crisis and emergency, with a particular case study devoted to his home country, which is Romania. Just to let you know that Professor Cercel has something like 45 minutes to 1 hour, and then we'll have the time for questions. So stay tuned, stay with us, and ask whatever necessary within the framework of legality and morality. But as I tend to say, since we're in a postmodern situation, everything now is possible, and the concepts of legal and moral are being currently deconstructed under construction. So you can ask whatever you deem appropriate. So Cosmin, the floor is yours. You can share also your presentation.
Okay, so thank you very much. I'm very happy to meet you. Dobr večer to those of you who are in Bulgaria now. And then, I'm going to start by thinking that this is going to be, I made a very long presentation, but, basically what I'm going to do, I'm going to shorten it up in a way and kind of trying to answer one big question of, how do we deal with, how can constitutional history, how legal history can help us to understand the present? I think really it's about that. And, initially I was thinking quite a lot about, actually having a very theoretical paper. Then things started to move in a very strange direction in Romania. And then actually, how to put it, I'm moving from theory towards something which is much more probably interesting to me. I hope it's going to be interesting to you. This sort of, meeting point between practice and theory, or, kind of political, historical trajectories which are coming together into something. So it's really more about, trying to make sense about how history is going to enable us to think what's going on in our polities. And, even though I'm going to focus my presentation on Romania, I just want to start with a couple of caveats. So basically, the first thing that, you might want to keep in mind is that basically by Romania, I don't necessarily understand the nation state Romania. Yeah, when I'm thinking of a particular space in which basically there are some sort of legal orders, legal ideas, political legal imaginaries, political legal ideas which meet, and then we call that thing Romania. But I'm not entirely sure whether, it is connected to the project of the Romanian nation state, but it's not Romania in a very kind of limited sense. Let's put it this way. It is more about ideas and concepts that circulate. And I'm going to try to explain you this quite in a couple of minutes about how this operates and what can comparative legal theory bring to that, what comparative constitutional law bring to that. But the main question that started to kind of puzzle me in the past weeks is how is it possible that things that we were considering to be done, relegated in the past, to be closed in the past, are repeating? Yeah. And you're going to see that basically in the last, we're going to compare the last two case studies, which is really about, Romanian fascism in the 1930s, and what's going on today, you have almost something like a reenactment. Of course, many things have changed. Many things are very different. Many things have changed. It's no longer the same actors, of course. But it is almost to the detail that things are reenacted. Even, you have this sort of reenactors, this sort of subculture of people who are dressing up as, kind of reconstructing the battle of, I don't know, 19, the Austerlitz, 1804, something like that, or this sort of, subculture. And you ask yourself, how is this possible? Why it is possible? And I felt that actually it has a lot to do with this sort of question of archiving the crisis. And it has something to do with the way in which law um, operates as an archive. And it has something to do with the fact that the law kind of keeps or finds itself at the interface between the past and the present. And it always builds on something in the past, and it keeps that past alive. And what I'm going to do in the next couple of minutes, I'm going to try to think a bit about what crisis it, and you're going to see that actually I don't have a lot on that, because basically I think that crisis is something that has to be understood in relationship to the law. I don't think that us as lawyers or lawyers of any sort of credence or any sort of intellectual positioning, we can access simply, crisis in other ways than just through legal lenses, whatever legal lenses means. And I'm going to bring in after that a number of questions which are related I pick from psychoanalysis, which I pick a bit from deconstructive theory, especially from Derrida. And I'm going to try to explain you a bit, how archiving works and what is this theory of archives, and how actually the law operates as an archive. And then I'm going to move towards, the case studies. Now, I'm building up on the number of texts that I've been working on for a while in the past, I don't know, let's say 4 or 5 years. So I'm building on that. In this sense, it is not going to be something extremely new. But I think what is going to be new in this lecture, and what I'm interested in, is I try to emphasize this moment in which law tries to capture the context of crisis, and what are the means through which the law is able to do that, and what happens when the law does that. So I think the focus is rather, let's put it this way, in a sense, methodological and theoretical, and towards the end is going to become a bit more historical. Now, we're living in an age of crisis, polycrisis, very well. It's, things are not going well. Yeah. I think one of the main questions that it is about, we need to ask each time when we're entering in terms of, conducting or, entering close to the notion of crisis is, what does it mean? Yeah? Because actually, in a sense, I mean, in many respects, a crisis has this sort of a dimension of being a political manner of determining it. It is a matter of decision whether a crisis exists or not. And I think Gian Giacomo has quite a lot to tell us about the way in which actually it is performative. Yeah, it is part of the performance of someone, of an institutional body, of an authority, and so on and so forth, who decides that there is a crisis. Because crisis, in many respects, is something which doesn't happen just out there. There are many things which happen out there, and we are not registered by the law or by the constitutional discourse as being a crisis. So in many respects, I think it is something which becomes discursive. It's not fully extra discursive, but it becomes discursive. It is integrated into discourse of the constitutional law or constitutional discourse through a performance. Through a performance of someone or of a specific body. And in that sense, it has a sort of, the existence of the crisis has something extremely political related to it. Of course, you're going to see, especially in the field of emergency, that this is the case, basically. And I'm going to try to convince you more with historical arguments around that time. And of course, I think this question is asked in any discourse. Yeah, it's something which is asked by economists, and they're saying, is this a crisis? By sociologists, people working in social studies and asking, or criminology, is there a crisis out there? And in the way in which they're going to relate to it, it is through their own methods and grammars and the way of distinguishing what a crisis is. Constitutional discourse has its own means of dealing with that as well. It's sort of, and it is based in most of the cases, and I'm going to get into that in a moment. It is based on, in most of the cases, on a particular authority performing the existence of crisis, or registering, but at the same time performing the existence of crisis. And we're going to discuss a bit more about this question in a couple of minutes. But I think what is useful to keep in mind, perhaps, and this is my my starting point, is that actually we always need to stay or to keep in mind that this is a process. So it's not something that there is a crisis out there and we just simply register. the register, in many respects, the act of registering the crisis, it is part of the same crisis. And the crisis, how to put it, the crisis, it exists already in the instrument. Yeah. So, I mean, what I'm just doing here is just kind of, asking the same questions that, we would ask in phenomenology. There isn't a sort of a distinction between us as the subject registering the crisis and the crisis out there. We are part of the same world. And in many respects, we are influencing each other in the act of registration or in the act of performance. And I think even the idea of the act of performance as of an autonomous subject, sovereign subject, it's to be questioned because of that. Because it always asks the question why the sovereign is performing the crisis. Okay, so we're moving to that in a couple of minutes. Now, I just want to draw attention of the fact that basically we are talking in legal theory for a long period of time, probably at least 20 years, 30 years, that actually legal theory and the conceptual apparatus of jurisprudence is in crisis, and it has been in crisis for a long period of time. And we can also say that legality in many respects is in crisis. So it's something that I've been writing and trying to reflect on a couple of years ago when I was still very much interested in legal theory as such. And it was a sort of a sense of desperation that I had around that time, like 5 years, well, more than 5 years ago, 6 years ago, when basically I was saying that actually the law is no longer able to stop the madness around us. Yeah, so it was quite clear that it's no longer able to do it because probably the mechanisms of the law for keeping in check other aspects of what are going on in society are not they're not historically they are not enough, and they are probably not historically clean themselves. Yeah. And I think that there has always been a sort of a strange convergence, and we can discuss about it, a strange convergence between the law as such and legality as it was built ideologically and so on, and various ideologies, because the law, it's not a pure instrument. It's something that has always existed historically, both in the heads of the jurists, in practices in society, and this sort of relations between the heads of the jurists and the practices in society. It's very complex, it's very complicated. Jurists are not outside society. They are also part of this world. Okay, now how do we get, if we're believing still, I mean, to some extent, I think it is quite important that we keep in mind this sort of, because we're lawyers, this sort of how to put it, relative or fictional, or how do you, it's very complicated to kind of define it, but this sort of specificity of the law or autonomy of the law in relation to what's out there, with a specific out there, with an outside. Yeah. And that's why I turned back, where I start with Kelsen. And actually Kelsen he's very useful in kind of trying to explain us how this sort of point of juncture between the symbolic and formal dimension of the law and an outside is produced. And we are always trying to imagine that basically there is an outside there. But Kelsen makes it quite clear in Pure Theory of Law 1934, he's making it quite clear that basically the moment when something it is registered by the law through an act of adjudication, it becomes part of the legal discourse. Yeah, so it enters the legal discourse as such. And actually the act of adjudication, the act through which the rule, the general norm becomes concrete, it is at the same time an act of lawmaking. Yeah, so it is law creation. So in many respects, this sort of juncture between the social realm and the legal realm, it is the moment where the social enters into the law. And it's not that it stays an outside, it enters into the law as such by the decision of someone. And I think it's quite important to kind of, keep this thing in mind. And, you have here a very long quote on that. But I think it's important that we keep this moment in mind in the fact that judicial decision in itself an individual legal norm, and that the function of adjudication is constitutive. It is law creation, and there a concrete material fact enters within the realm of the law. And I think this is the sort of a very important moment for keeping in mind that actually crisis can be archived within the law. And when the moment in which it's archived, and here I draw on the work of Hans Lindahl on the politics of illegality, the moment of when the crisis is registered into the law, it's also a moment of crisis of the law. Yeah, so it's really a moment of illegality. That very moment, when a judge takes a decision and decides that something exists in the world, it is a moment when the sort of the legal order, for a moment, it is suspended. And it's something on which Carl Schmitt wrote quite a lot. It is a sort of a moment that the individual decision in itself suspends for a moment the law. But for Kelsen, what is important is that actually the law, it's grounded in reality in that moment. Yeah. Now, what does it do? And now I'm drawing and I'm moving towards the question of theory of the archives. I think that there is a very interesting thing that happens when the law is able to register, well, and especially you're going to see later on, constitutional law is especially able to register the crisis, is that basically something enters and stays there. Now, and it stays there in a sense that it is consigned in the place of the law. It is consigned within the law. And I think here it would be very interesting to kind of, I know I'm a bit speculative, but it would be very interesting to see why there are some parts of the law which are the privileged space in which the crisis is consigned, the archive of the crisis is consigned. And you're going to see that, I mean, actually, there are a couple of areas of the law which are were consigning basically materiality. Yeah? Criminal law, constitutional law. Why? Because basically they are very close to that. They are very close to those moments. And those moments are very, interesting. And here I quote from Derrida that basically, if you're looking at it, there is a sort of a clear relation and historical. You can discuss it. We can discuss about it. It's sort of a formal, but at the same time, historical relation between the act of archiving and the exercise of the law. Yeah, I mean, we always know that basically, historically, actually archives in its very meaning, it means, kind of keeping power somewhere. It is kind of the origin of power. Okay. I think this is important because, in the text of Derrida on mal d'archives, the archive fever, he's always thinking about the fact that actually there are two tendencies which are present in our society in relation to this. On one hand, there's sort of an obsession of archiving things, and that's what we do with this power which tries to conquer reality and to kind of, keep reality within itself. And then on the other hand, there is a sort of a obsession of a possibility of destruction of the archive. So the moment in which we're archiving everything and, all the power enters within the sphere of the law, and then there's not going to be an outside of the archive, that might be the end of the archive, yeah? And this is also very much related to a sort of an obsession of not leaving any trace in our, in our psyche. It's not, more. It's much more a sort of an, anthropological claim that he's making there, and he's making that in relation to the work of Freud. And I'm going to get back to the work of Freud because I think Derrida brings together the idea of an obsession of keeping an archive and at the same time the possibility of destroying the archive. And the possibility of destroying of the archive is really about the question of, he calls what Freud calls the death drive, this sort of, capacity or, drive that we have as human beings that's moving towards death. And in actually engaging against our own interests, basically, interest, pleasure, and so on and so forth. But even in his work, Derrida kind of tries to say, well, actually, there is well, the archive is something which is related to power, but is not only absolutely related to power and so on and so forth. The interesting part of it is that there are other authors who carried on the work of Derrida, and then they try to bring that into the question of the law, like Renisa Mawani. And she was saying, well, actually, look, law is the archive. Law is the archive, everything. This is the way in which everything is registered. Everything that goes around us, it is registered. And it is registered. There is nothing that actually escapes the archives of the law. And I think it's a very interesting point that she's making, and we can discuss about it. But just keep in mind that actually the archive, in a sense, it is a place, a legal place, and at the same time a place which is determined by inherent, kind of struggles, tensions, and so on and so forth. Okay, now how do we get with this? How do we, because still, when we have the power taking over something, what I feel so far that in this sort of question of archiving, and both in Kelsen and we're moving in towards Derrida, there is not sort of a moment of rupture or a disruption. The law kind of, functions without sort of a major disturbance. And we all know that basically crisis is about something else. Crisis, if you live it, and it's this time I'm just, kind of building up on my own experience of, things that I've seen and experienced and so on, you feel that in a situation of crisis, things are different. They're absolutely different. It's not, the moment when the COVID pandemic was declared, everything changed in that moment. The moment when, you have a curfew, as we had in Brussels in 2016 after the terrorist attacks, you feel that things are not the same. And the crisis we had in Romania, you just felt that things were not the same. For the past 3 weeks, we have been living a sort of a strange tunnel, in a very strange tunnel. And I think this is really related to something, and again, I think that the psychoanalysis can help us to kind of explore that. And it's not about something being in our brains. It's much more about, how do we understand this notion of an excess going outside, something which is an outside. There is an outside that the law has to capture. And then I'm speaking about the law, constitutional discourse, and so on. We're looking at them as, I'm looking at them as being formal systems. They are formal systems that try to deal with something that exceeds them. Yeah. And I think psychoanalysis enables us to do that because basically in psychoanalysis, you have the capacity of, what structures reality. In Lacanian rereading of Freud, what structures reality? It is the symbolic order, which is a mean of a kind of a formal system that that organizes life around us. Yeah, and basically this is always based on a lack. There is something that, you need to have this sort of, how to put it, this sort of formal distinction between things, a sort of formal mediation between things in order for reality to be structured. Yeah. So basically you need to stay away, you need to be away from desire, well, what is called the drive, pulsion, and so on and so forth, in order for reality to be structured. Now, when he was talking about the question of anxiety, Lacan was saying, well, actually, this is probably the most important affect that humans have, because basically in it, you're registering the capacity, this sort of uncertainty of the existence of the mediation. And I think this is something very interesting in relation to crisis, because in crisis, what's happening? Everything that enables us to keep a distance to reality, or to structure our reality, is dissolving. And what is dissolving is really this sort of kind of capacity that we entertain with that. Okay. And then you have here about a quote from Julia Kristeva. I just put it there because she's an important Bulgarian psychoanalyst who also had a very interesting life. But I think, Julia Kristeva, look, beyond all her biography, or because of all her biography, I think she was able to capture quite well, what's going on in this sort of situations, yeah, which is about power, distinction of, kind of this sort of mediation, lack of mediation, and so on and so forth. Okay. let's move a bit about, why I think, there is a sort of an important thing in emergency, because I think emergency can be, well, we're working on this in many respects, but I think that emergency has this sort of specific characteristic of grasping all the problems of archiving in a sense, because actually and specifically the way in which constitutional law acts as an archive. Why? Because in emergency, depending on the type of emergency, the model of mediation, and so on, you have institutional actors who, most of them, they are of constitutional interest and importance, who are basically registering the crisis. They are those who are kind of being there. I mean, in the classical formal, models of accommodation of emergency within constitutional discourse, you would have someone like the president declare the state of emergency and then basically going to the parliament and informing them about that. Yeah. Or you have the declaration being taken by the parliament, and later on the president is empowered to that. Yeah. But there's always this sort of, strange lines of, who does it first, who is able to register it, because look, there are many historical reasons for that, and who has this primacy of declaring that there is a crisis out there, and because there is a sort of an important political dimension behind it. Yeah. And I think emergency enables us to see what's going on also later on, after that archival moment or the moment of archiving has been produced. Because later on, and I'm just going to try to give you a very short example, and I'm going to fast forward through a number of slides, going to see that basically these sort of things produce strange things. I mean, strange effects, which cannot be explained just simply as a matter of, coincidence. And I think the interesting part is that they are, how to put them, formally similar. And they are formally similar and they travel across contexts. And I'm going to give you an example, just a second, just in a okay. So what I've been working through this year was basically the way in which the emergency, the specific type of emergency legislation, the state of siege, has traveled from France to the Romanian principalities of that time, and actually travels very fast. From 1849, it traveled to 1852. It was, we had the legislation of the state of siege, which existed within the Romanian within Romanian legislation. I mean, the legislation of Wallachia. Military legislation. Later on, we had the law of 1864, which basically was a translation of the law of 1849. But basically, already in 1852, we had something like this. Yeah, and it traveled via Russia, because basically it was a translation of the Code of Military Justice, and on the translation of the Code of Military Justice, of the Russian Code of Military Justice, which was applicable to Romania for various reasons. We had Russian troops coming all over the place, every 10 years through 19th century, 18th century, and 19th century. And then basically to that, they have appended the law on the state of siege, under the conditions in which basically Wallachia didn't really have a formal constitution. We had just had the material constitution of sorts, kind of customs. No, we had the organic regulations, and it was this sort of state of siege which was produced there. 1852, then 1862, we had another type of formal constitution, but things are traveling fast. But what is the core? And I've been working, trying to guess what was the core of it, and what was the core of the French legislation, and what they were thinking about when they did the state of siege. Well, basically, it was really about trying to prevent or, kind of protect society and organizing the state in front of danger. Military danger initially, and then you're going to see that basically they moved from military danger towards something which was sedition, towards internal dangers, towards insurrections, towards many other things. And basically this sort of notion of danger it moved from being a purely military one towards any sort of danger to the state. It became a very spurious and vague concept, and it was no longer material concept. And then basically you have these origins in 1789, and you have, and everything, every moment of this, I mean, every moment of, kind of conceptualizing this, it was based on, I mean, it was based on a form of archiving. It was based on a sort of a moment of, trying to understand what's going on in society through means that were done by the legal means, but also by political, the political representatives trying to think what it is about. And you see how actually things were moving, quite a lot from, and they were merged a lot this in terms of kind of military tactics, military thinking with legal tactics and legally thinking, which is a very interesting kind of way of doing things. Yeah, so you have this sort of information here, but what is interesting is that basically by the time when you have on the left side you have this guy who's the prince of the first prince of the United Principalities. On the other hand, you had Napoleon III. They were dressed very similarly. You can see, they also had the same mustache, the same kind of stuff. But what I think is very interesting is that actually what you have there is a way of through which authority is produced. The authority of the state, it is produced and it can be saved at the same time. Yeah. And it's something which is interesting because if you're looking at the trajectories of these two characters, I mean France and Romania, and they were very much related to the state of siege, to the organization of both France and Romania, and so on and so forth. Basically, both of them, the moment when they start kind of entering into this logic of the state authority and so on, they are moving beyond the constitution. That's the first thing that happens. They're kind of acting as authoritarian leaders. And I think it's a very interesting part in the history of, constitutional history of France that, basically Napoleon III is one of the he's a very modern character. He's the very first one who kind of, transgresses the constitution several times, attacks it and so on and so forth. And then all of a sudden he just takes the authority of saying, well, I'm going to change the whole legal system because, who cares? I'm the emperor and I have the military on my side. Which to some extent also the Prince Cuza tried to do, and it didn't end up very well for him. But even furthermore, if you're seeing, and this is the interesting part of it, this sort of acts of archiving, and you always kind of, building this sort of, slowly building this sort of notion of state under danger and state of siege, it ends up with very serious uses of the state of siege, which are, moments of serious repression, and they are very similar. I mean, the way in which the French authorities repressed the French Commune is very similar to the way in which Romania 30 years later repressed, peasants' uprisings. And, I think that, and actually the legal mechanisms through which they did it, it was the same. And, of course, the comparatist in me many times just thinks this is impossible, yeah, because obviously the text, it's in a different language. Even though the military, they were speaking more or less, the officers in the army, they were all been trained in France. So, things are much more complicated than that. But, the comparatist in me sometimes just tells, well, how is this possible? It's a mystery in many respects, because on one hand, you have a sort of an important imperial country, and on the other hand, you have a country which is, we're neighbors. I mean, it's not, we might have, kind of imperial projects in mind, but it's still a sort of what we could call somehow periphery, yeah? And I think it's an important thing about this sort of question of archive, because the law keeps something in itself and you kind of push this a bit further. Okay. Now let's move towards the kind of more complex analytical stuff, and we still have about 20 minutes, right? Or yeah, 20 minutes, 25.
As you wish. I mean, we don't have the whole time of the universe, but otherwise,
Okay, good. So yeah, let's try
27 and a half.
Perfect, 27. Okay, excellent. That's perfect. Thanks. Okay, so now I try to be a bit more detailed. So far I kind of fast forwarded, but now I'm going to try to be a bit more detailed, because I think it's important to kind of see how actually once emergency is in place, you have this sort of legal framework, and you shouldn't forget that actually this legal framework was built on various moments of this sort of archival. And you can look at this sort of legal, what to put it, legal institution, or constitutional institution, because I think it's much more, it's not simply a legal institution, as layers of moments of archival, as layers of this sort of moments in which and it is an archive in itself. Yeah, I think it's a very specific domain of consignation of those archival, of those sort of historical moments that they got put in. And then once this sort of archive keeps on piling up, something starts to happen. Yeah. So we had the first emergency, serious emergency that was addressed by the state of siege in 1907 was this peasant uprising. But that was it. We had a couple of them later on during our, well, imperial ambitions and adventure in coming and occupying Sofia in 1913. So that wasn't a good thing to do. But still around that time, if you're reading actually what the constitutional lawyers of the time, how they were reading the constitutional discourse, they were reading the Romanian constitution as being a liberal one. Yeah? They were looking as emergency, as the state of siege, as being actually, first of all, non-existent, because it came from it was produced under the regime of a different constitution, the constitution of 1862, which was really just an amendment of a international treaty, whatever. But it wasn't produced under the regime of the Constitution of 1866. So basically, they are saying, well, doesn't exist. There were, many, important commentators were saying it doesn't exist. It's not existing. It is not there. The state actually, when was using it in 1907, they were using an anti-constitutional text. It was not even in the legal order. And other people were saying, well, we might have something like this. So this is cool, but basically, we have to think in terms that actually, if the state is going to push these things further, there's going to be something like the right of resistance. Yeah, it's not. They were talking like this before World War One. Actually, this was this kind of the general discourse of kind of the fin de siècle liberalism in a country which was very much uneven, unequal. You just have to think about the fact that the vote was based on census, constitutional politics was basically directed and devised towards 6% of the population. That was it. We had many people. We had around that time at least 1/3 of the population who were illiterate. What we were talking about. It's a very sort of interesting thing just to think about, the social dimension of that. But hey, now after World War One, or during the World War One, what happens? This emergency enters within the mechanisms of the state, and you can see quite well that at least for a period of time during the 20s, basically there is a sort of a tension between the fact that on one hand the state of siege is being accommodated within the legal system, and on the other hand, that there are people like, activist lawyers like Constantin Costaforu, who is saying, well, actually, even if we have state of siege doesn't mean complete destruction of legality. Yeah, just a parenthesis: state of siege means the transfer of all order maintenance and sometimes jurisdictional authorities from civilian authorities to military ones. Yeah, so it's really about kind of transfer from civilian authorities to military ones. Otherwise, meaning kind of power given to the military in order to organize, to order society and to deal with the danger. And basically, we had this sort of uses of the state of siege in contexts which were, we could call this context, quasi, colonial, or colonial, not quasi-colonial, perhaps even colonial. Yeah. So basically, newly acquired territories after World War I, in which basically, and especially, southern Bessarabia, southern Dobroja. Mihai is working on southern Dobroja. That they were basically, if you're reading quite more about what the Romanian potentates or kind of authorities of that time, how they were looking at these territories, they were looking in a very colonial manner. Yeah. So you have here a photo from the repression of the an uprising that took place in southern Bessarabia in 1924. And basically, it ended up with 500 people who have been rounded up and put on trial, all of them. Yeah. So, and then still around that time, the military tribunals, under a lot of pressure from the public opinion and European public opinion, not only Romania, they managed to keep some form of liberal legality even within the sort of situation of the state of siege. But things are changing, and are changing already quite a lot. I think that was a very important moment, 1924, 1925. It was a very important moment because actually that's the moment when the far right in Romania starts actually to say, well, look, the state needs authority. Liberalism, the liberal frameworks, the legality, all of that, basically what they're doing, they're just destroying the legality, the authority of the state. And then you have for the first time that basically in constitutional academic commentary, you have kind of strong moments for saying that actually the state needs to be protected. Yeah, it's already, well, you just have to think it's about 15 years from that. Yeah, I mean 10 years from this moment. Yeah, you just compare, what Disescu was saying in 1915 and you compare to what Neculescu was saying in 1925. It's 10 years that they are radically different ways of thinking. Yeah, it's no longer about, this time they're saying that even extralegal means basically can be used against the people. Now, I think you have this case of a judgment in a constitutional review, which is quite interesting because it kind of signals the way in which actually by 1934, the uses of the state of siege and of the emergency were part of the regular organization of the state. And I think it would be very interesting to think of this text in connection to what I'm going to talk at the end of the presentation. And it was a constitutional review petition that was made by a foreign national who actually was put on trial for espionage. Because basically he was in possession of secret documents that he shouldn't have been in possession of, and it was all. I mean, the guy, he was the representative of the Skoda factories in Romania, who are involved in a rigged public procurement process for the Romanian military. And everything got into the public eyes, and it ended up with a important, corruption scandal. And the press, and actually it moved, it well, it ended up with stepping down of the president of the National Peasant Party, who was an important figure around that time. But I think it's an important thing. It was an important moment when, for the first time, quite seriously, people are talking about corruption in very hardcore far-right terms. And this sort of the discourse of the far-right over corruption is taken, in terms of anti-corruption is taken, and it's articulated quite strongly. And they are coming together, and they're coming together. On one hand, this sort of an idea of, saying that the state of emergency is something which is absolutely normal in the uses of the state. As you see, that the government has done no more than to merely make use of the power that was granted to it by the legislator. So basically, there is nothing exceptional about the state of siege. There is nothing exceptional about emergency. It's kind of everything is kind of put down as being a normal a normal situation, which of course it wasn't. But of course it becomes normal, because if you're looking at, how many times the state of siege was declared after that, and how under which conditions it was declared after that, you see that things were, yes, on one hand, what was normalized, it was the emergency, and the exception was normalized. And that's something, we should keep in mind, at least, for what's going on today. But each of these documents and each of these moments are actually ways in which crisis has been registered by the legal system. Crisis has been archived, and it keeps on piling up, and it keeps on piling up. And it ends up with this guy, who was the king of Romania, who just says at some point in time, he's just going to say, well, look, I don't want to bother anymore with declaring the state of siege, recognizing the state of siege, going to the parliament, asking the parliament again in order to grant me powers to declare once again the state of siege, and so on and so forth. And it just says, well, of course, things are much more complicated, but from our perspective, constitutional discourse, what's going on, he's just saying, well, actually, I'm going to produce a continuous prorogation of the state of siege. And after that, I'm just going to get rid of the parliament. And it's a very important moment in which basically all the democratic protections and so on, they are dispensed with. We don't use them anymore. That's it. And you can see that actually some aspects of this, at least, I don't know, I've been kind of repeating this for a while, but I find them somewhat funny, because basically one of the conditions for in any definition of, constitutional dictatorship, whatever, state of siege, emergency, and so on, one of the conditions for that is that actually they are temporary measures. Yeah, and even around that time that existed this idea that they should be temporary. And then basically I find it always funny when I find this is like the state of siege will be lifted when it will be deemed appropriate. So basically it's still somehow temporary, but it's temporary when the king wants it to be temporary. It's kind of. And if you're thinking about it, this means, and that's probably the interesting part of it, it means legally that the constitutional system keeps on registering the crisis. So the crisis is ongoing, and it's there, it's ongoing, it carries on. And that's why, probably we should look at the Constitution of February 1938 as being kind of a constitution of crisis. Okay, what happens then? And, you're going to see now how things are coming back to, what's going on these days. There was an important, the main challenger of King Carol II was since 1935, actually, was this movement of, we call it a fascist movement, and historians of fascism sort of disagreed, because some of them, they are saying, well, actually it was such a peculiar movement that you can't really consider it as being part of the generic fascism. Then the generic the theories of fascism kind of build nowadays, they consider it as being probably a core movement for defining generic fascism, because it contains quite a lot of kind of this sort of elements in excess of fascism, which precisely make it sort of a generic. So, it's a very interesting discussion about that. But basically, this movement, they were called the Legion of Archangel Michael. They started kind of their operation around this time, yeah. So around 1919, yeah, the very first organizations of that. They were fighting communist Bolsheviks. Later on, they allied with another party, and their main goal was to block the Constitution of 1923 because they didn't want to have to grant rights to minorities. Yeah, they just, they were ultranationalists on that. And then because the other members of the party, of the right-wing party, it was called LANC, the League for National Christian Defense, they wanted to carry on the sort of democratic parliamentary, route. They were very radical, and at some point in time, they just ended up in, I think it was already, 1926, I think, yeah. They formed a splinter group, and after that, they produced what it was called the Legion of Archangel Michael. Now, this character whom you see here, basically, he has been always on the radar of Romanian authorities, and he has been charged with murder once and acquitted. No, yeah, charged with murder once and acquitted, charged with conspiracy for murder twice and acquitted. You know, charged with I don't know how many other things during the 1930s. The movement was dissolved several times in 1930, after 1933, because basically there were death squads who killed the Ministry of Interior, the Prime Minister of Romania. And then basically by 1938, they were considered like a serious threat. I mean, and it was not it was a known secret for everyone that they were a serious threat. And we can talk about it, and it's a sort of, we can discuss a bit more about the details of it. But what I think it's interesting is that around this time, so just after the state of siege becomes the sort of an important part of the mechanisms of the mechanism of the state, they take action against him, and the first time it is by a trial for contempt of authority, which is almost ridiculous, but yeah, and I don't think that there was serious ground for that, because if you're looking at it, there wasn't. But actually, in May, they also charged him with treason by possession and public reproduction of documents concerning the state, conspiracy against the social order, sedition, and violations to the high degree of the state of siege. And everything is happening under this shadow of the state of siege. So if you're looking all the kind of, because I've been looking at the documents of the trials, and then everything is done in all the which are part of the ways in which everything is archived. Yeah, in all the interrogatories, there is a question which is done: are you aware that what you have been doing was done under the conditions of the state of siege? Which it's a very interesting, way in which basically this emergency already is part of the process of archiving itself. Okay. Now he is found guilty. And then that's not considered to be probably enough that he's found guilty, so he's put in prison. And you just want to see here what sedition is, how it is, there was this sort of idea of a civil war and so on and so forth. He's put in prison for 10 years. Because they had the paramilitary corps. And after that, he is shot. Yeah. He is shot by trying to flee, apparently in an attempt to flee from escort. And, this was in Romania, in the history of Romania, basically this was another word for saying that he was shot because he was considered to be dangerous, because this was part of what actually the gendarmerie, and there are Romanian historians who are working on that, like Mihai Burcea, for instance, who were writing on the uses of extrajudicial killings by the state in ever since late 19th century. And I think that's sort of another point which is important to kind of note for what I'm going to say in a couple of minutes is that actually he became a martyr, and he became considered a martyr for many of his followers, and he was entombed somewhere nearby there where he was shot. There were many other things going on when the fascist movement came to power in 1940, because they were in power for about 3 or 4 months. And they also engaged themselves in extrajudicial killings of the opponents of the people who actually shot the leader of the movement. But that place has become a sort of a place for ceremonies for all the neo-Nazis in Romania and the fascists. And actually, around the time of the elections, basically, there was a moment when the fascists Romanian fascists gathered there publicly in front of the police. The police was not doing anything because there was this moment when, it wasn't very sure what's going to happen. So, actually they might be the tomorrow's, people acting in the public authorities. So there is a sort of an important symbolic connection between this story and this other story. Now, the other story starts this way, and I'm just going to try to explain a bit, the context behind it. So what's the context behind it? I think it's quite important that, basically things in Romania were moving in towards a very nasty neoliberalism since 2011. I think there were moments to that, but, 2008, 2009, there was the financial crisis. After that, we had the sort of a serious austerity. You could see precarity, inequalities, privatization, commodification, and so on and so forth. Just to give you an example, I don't know, the day before COVID started or was declared, our government, which was of a very neoliberal streak, and they were all very nice people. It's not, that don't think that's a problem in itself. They've passed 19 emergency ordinances in one day, and all of them, they were in a way or another connected to the idea of privatizing, healthcare. I'm sorry, it was after the World Health Organization kind of sent a signal there's something there, yeah. And then, 2 days after that, there was, or the next day, the pandemic was declared. It's just absolutely crazy. And they were the good liberals. I'm sorry, but it's kind of, 19 emergency ordinances in one day. I mean, okay. Now, we also had a very long and complex history of the presence of the far right in the public sphere. And, people who have been monitoring this, historians, researchers, political scientists, and so on, they've been saying for at least 10 years that something is growing and is not normal. And, I've been one of the people who was kind of saying, well, listen to them. Yeah, I'm a legal historian, so I'm not, kind of that close to what's going on there in their groups. But I know many historians who know very well, what are the connections between the fascist movements our days and, the connections with the historical fascism, and how actually there are connections. It's not that they, actually the legionaries, they never sort of, they carried on. I mean, some of them, they lived, some we can discuss about it. And it's a very important thing to kind of, needs to be discussed and, kind of took into consideration. Then there was also the question of populism, which I think, we have been spared, Romania, as from the question of populism, but I think it was also a specific way in which we as constitutional lawyers and many of us played this sort of a very ambiguous role in, naming this thing populism, because in many respects, at least, for the case of Romania, but in other places as well, we were dealing with far-right authoritarians. And I think this is something that had to be spelled out in that particular sense, yeah. Then there's also the question of anti-corruption. Anti-corruption in Romania was always a political battleground. And, there were many questions about it. It became at some point in time a very blunt instrument. And, it just became into something like, oh, you're corrupt. No, you're corrupt. And then you're corrupt. And you're corrupt. No. And then, I'm pure and so on. And actually, it was very useful as a sort of a discourse in society. And people believed it because I think, we also have, in a sense, nobody wants a country to be corrupt. And it became very strong. And there were signals already by 2019 that there is a sort of an important popular mobilization around corruption, against corruption. I mean, there was a sort of a lot, and that was good in many respects, but at the same time, it was worrying. At least, for me, it was worrying. Why? Because, and I wrote this text that got published this year. Actually, many of the words that people were using, either in public discourse or in the discourse of the institutions in relation to corruption, they were using tropes that were sending back to the 1930s. And they were talking in very similar words and very similar frames. And I think that's a sort of very important to keep in mind. Then we had COVID, and then the COVID was really complicated. Why? Because in many respects, it's not a very rich country, or the state is not strong enough. So in many respects, the messages that have been very mixed. And there were many people who are saying that actually what was going on there was a sort of at least for periods of time, there was a form of criminal law or penal populism in saying, well, we're just going to use criminal law / emergency measures to deal with the problem, but not medical emergency measures. just kind of this sort of pure repressive measures. I mean, we can talk about it. Some of them, they are kind of ridiculous, but that also produced a backlash in terms of anti-vaxxers, all this sort of Telegram organizations, all this sort of a lot of stuff, and a lot of uncertainty for the people, because before, just have to think about it, and then I move on. Before COVID, I mean, days before, we are talking about privatizing the health system, and then all of a sudden, the state presents itself as it cares for its citizens. Why? I mean, it doesn't really make sense. It's kind of, why before you're not taking care of me and now you're taking care of me? Well, of course, because there is a pandemic. But then, try to explain it, try to pass this message. And anyways, good. Now, what happened? So you have a chronology here. So on the 5th of October, I think it starts with the first far-right candidate who, by a decision of the Constitutional Court, is her act of candidacy is invalidated, and it's invalidated on grounds which are related to her ideological creeds. But many people consider that the decision was strange because there were at least other two candidates in the presidential elections who would have fitted quite well the picture. So why one and not the others? I mean, at least this was one of the arguments. And then, there were many other people who are saying, and, the vast majority of liberal commentariat was going in the direction that, well, actually, this is a blunt instrument. If we got to the point of, using a blunt instrument, as blunt as this, things are not going in the right direction. And, basically, that's going to produce a popular backlash. You have the first round of election of the far right, and you have candidate Călin Georgescu, who is ranked first. And that was a surprise for many, especially in the kind of, once again, the liberal circles. They were thinking, well, who is this person? Because they never met his name. I mean, I knew about his existence. I knew that actually where he comes from. So, yeah, I mean, it was for me, it was a surprise that he made it on the first round. I mean, he made it on the first rank. So, yeah. Then you had two petitions to the Constitutional Court made by two minor candidates who lost the elections, obviously. First one was seeking annulment for the elections for irregularities. Another one was seeking a recounting. The first claim was considered to be barred by the court because of a statute of limitation, basically. The second one gave rise to recounting the votes, and on the same day, basically, the Supreme National Defense Council held a meeting and decided that based on the information that they had, there has been a major interference with a foreign power in the elections. On the 30th of December, there is a growing sense, at least, in kind of the Romanian media, that there was some Russian meddling. Then on the 1st December, there were legislative elections that were held. And on the 2nd, there was a level of, let's put it, popular mobilization, people kind of starting to be a bit afraid of what's going on. Official statements that were made by various bodies, universities, College of Rectors and cultural organizations about the dangers of fascism in democratic society, the dangers for democracy and so on. You have a lot, people taking public stands against the far right candidate, and then you have on the 4th a sort of a full institutional response. So the files grounding of the decision of the Supreme National Defense of the country are declassified. The press takes on the trails of the Russian money. The prosecutor's office starts an inquiry into the matter. And then on the 6th of December, you have the decision of the court. And I think there are a number of important things about that, especially related to the way in which, crisis is archived. And first of all, I think, the main point of contention for across the board, at least between lawyers in Romania, was around the question whether actually the court had jurisdiction, because it assumed or it claimed having an original jurisdiction on the matter. And it's just saying that basically, look, what the court is doing is just part of the duty that they have in order to oversee the observance of the procedure for the elections. And then basically what they're doing is, this is part of, this part here, yeah? The role of the Constitutional Court of guaranteeing the supremacy of the Constitution. So they kind of said, well, actually, we are defending the supremacy of the Constitution by taking this decision. And what was the decision about? It was, based on the finding that actually there was the elections were not free. Yeah, and so the vote was distorted, and the fair nature of the vote was, vitiated, and basically there was the whole process was distorted, so they had to kind of take the process back. And you have kind of an explanation in paragraphs 11 and 17, and you can see that obviously there are kind of references to the documents, to the declassified document, to the declassified documents made by the various state bodies, the Ministry of Internal Affairs, the Secret Services, which grounded the decision of the Supreme National Council for the Defense of the country. Now, this is pretty much it. Actually, the decision in itself doesn't talk about anything, and I think this is where I'm going to kind of try to conclude. That's one of the most interesting thing about the way in which the process of archiving is done, because there's always something which is left outside. Yeah? And here you can see that basically what is left outside and pushed outside, it's a decision on the process. It's not the decision on the substance. What is decided here, it was that the process has been thwarted with. It's not a decision on what was going on there. It was not a decision meant on the ideology of these people. It was a very neutral decision, if you want. And I think it's something which kind of, it doesn't enter into the question and the decision of the court. And I think this is something quite interesting and important. And, there are many people who are kind of nowadays saying, well, well, actually, democracy died in Romania. I don't know. But there is also the important question about, how do we deal with this? Yeah. And it's a difficult question to kind of to answer. What does it mean? How is it possible basically that after, I don't know, 70 years or 80 years since the disappearance and the disappearance kind of the fascist movement, um, and after about 80 years ever since, kind of the far right was kind of disappearing from Romania, we ended up with this. And then, just to give you an example, in one of the electoral speeches that this character had, um, basically he was repeating word by word one of the speeches of Ion Antonescu, who was the leader of the country, far right leader of the country during World War II. I think this is in itself should enable us to think quite a lot about what's going on there. And I come from critical legal studies. For me, law is politics. So I think, the whole question should be kind of put in these terms of, what does this decision say about, our position in relation to history? Um, and, I just stop here. But I just think that actually thinking of in terms of archiving and history and, in this sort of way, we can understand perhaps better what's going on today. Yeah.
Wonderful, Cosmin. Thank you very much for
Thank
your
you.
very interesting lecture. Quite informative, but also quite thought-provoking. So may I ask you just to stop sharing the presentation, just to be able to see each other better. Actually, we have also applause here from the public. I find several topics that you raised remarkable, namely the fact that actually law usually pretends to be a key framework setter, a regulative machine, whereas de facto it's much more a memory map. It's much more an archive of our collective experiences, dreams, hopes, fears. And the predominant rationalist positivist trends in doing legal science actually do not do justice to this anthropological, cultural, imaginary dimension of law. But also what I find fascinating is that we should really put forward the idea that sometimes crisis is not necessarily an objective phenomenon. Sometimes crisis is a produced masquerade. It's a form of dramatizing objective phenomena for the sake of producing emergency constitutionalism. And that's what we witness also in the history, but also in the recent past. And that's what we are going to witness in the future, because I strongly believe that in the context of constitutional polycrisis and constitutional polytransition, these crises, the imaginaries of crisis and fear massively shape what some authors call constitutional make-believe, and such as Castoriadis or others, and also we are now stretched in what Günther Frankenberg defines as constitutionalism between magic and deceit. So there is a lot of dark magic out there based on the imaginaries of crisis and fear concerning terrorism, external and internal threats to security, migration, but also pandemics and threats from the future. I just forgot to announce that actually we just published a couple of weeks ago, maybe a month ago, together with Cosmin, but actually with other brilliant scholars, a very interesting, I would say, special issue of the Review of Central and East European Law. I have the pleasure and honor to be the editor-in-chief, to be the convener of the people, but that special issue is called Constitutional Imaginaries in Central and Eastern Europe. It's published with Brill, with the Review of Central and East European Law. And if you are interested, many of the papers are open access. so you can access them directly on the web page of the journal. I just want to announce also that these lectures, including the current one, are put on the YouTube channel of the project, so you can, if you're interested, you can watch them again after the moment they are presented online. Having said that, I'm opening the floor for questions and comments from the audience. Please feel free to intervene. We're very much interested in the feedback, I suppose. You can ask conceptual questions, but also topical ones related to the ongoing processes of archiving the crisis and emergency. Yep. Don't be shy, don't be afraid. Yeah. By the way, maybe I'll just
Okay.
question as an icebreaker. We witness many resemblances, in these political speeches, directly or indirectly referring to the past, especially the interwar period. And I think that, for example, the famous speech of Viktor Orban claiming that we should stop experimenting with liberalism, but we should actually go back to the roots of the healthy majoritarian democracy. That resembles to me a lot the speech of Schuschnigg and Dollfuss in Austria, that in their proclamation of their ascent to power said, well, maybe liberal democracy or parliamentarism is something good for England because they have good experience with that, but it's not appropriate for the Ständestaat traditions of the good old Habsburg societies, and particularly for Austria. So this going back to the roots is kind of a traditional strategy for promoting neoconservative turns. Also Napoleon III, in his ascent to power, because you place that beautiful pictures there. He said, let's stop, when he was proclaimed an emperor, that let's stop with this experiment with some lunatic ideas of unstable men, let's go back to the roots. And then you ask yourself, which are the roots? Because the roots could have been the legitimist monarchical roots or the republican roots. He said, let's go back to the roots of the good old empire of His Majesty Napoleon I. So do you think there is such
Yes, I think it's great. I think it's a very important question. I think, first of all, like a sort of an appendix on Dolphus, the text that when I was talking about Kelsen, I just wanted also to point out that basically when he was writing those things, he was writing just before, those moments in which, just before in the wake of the civil war in Austria, basically. It was a sort of, actually the pure theory of law was also an archive, if you want, but at a very sophisticated level of a crisis, basically, a very serious crisis that was, unfolding in the before the eyes of Kelsen. And I think it's something which we shouldn't forget, that, basically, let's put it this way, our own legal frame, our own intellectual frames of kind of, dealing with crises that have been influenced by that. Yeah, kind of fundamentally influenced by that. Then, on getting back to the roots, okay, I'm speculating a bit. You're absolutely right. It's sort of, this sort of always getting back to this sort of an idea of majoritarian and so on. But, I'm speculating, but still, they were playing. One of the things that the legionary movement in the 30s was playing with discursively. And then what you have it now in the names of many paramilitary organizations in Romania have this sort of references to the folk heroes of 18th century, early 19th century, the Haiduks. Yeah. And basically, the attempt, at least, the alleged attempt of 20, paramilitaries to come in Bucharest on Saturday, armed with machetes and all that sort of stuff, is resembling a bit of that. The roots. I mean, some historians, they look at the roots of Romanian kind of modern politics as being 1821. Yeah, so the uprising against the Ottomans, which was concerted together with the Filichieteria up to a point. So the sort of the beginning of the Greek war, the Greek Revolution. So this sort of kind of, because there was a sort of a Romanian or Wallachian uprising which was concerted with that, and there is perhaps the sort of which took the form of a popular unrest, which was raised by a person who actually was a former military, yeah? So a former Russian military. And he was an Austrian subject. So being an Austrian subject, he had, some sort of, fiscal privileges in Wallachia. He was a sort of an important person. Now, I'm talking all about this because, he's a very important figure in kind of the region where I'm from in Romania and so on. But I think that there is something of that, kind of,
Who
there
is
is
that? Who's the name of that person?
Tudor Vladimirescu, who was described by the French diplomats of that time as a man of an obscure statute, of an obscure status. Yeah, of an obscure status.
Why is that?
Because he was a former mercenary working for the Russians. I mean,
Ah,
that's how he was described in the documents of the time. He was described as a sort of a man of an obscure status. So because we didn't know, he was. I mean, it was another way of saying that he was a nobility, and then there was also another way of saying, well, actually, he's a sort of a strange character. But okay, so that's a sort of a level of speculation in terms of what is the imaginary behind it. This sort of an imaginary of a kind of a popular uprising which is going to kind of completely change the system. And it's, you can play with it quite a lot, basically, in terms of narrative, kind of tropes and so on, this sort of new beginning. Yeah, I think really it's about this sort of new beginning and kind of, because one of the things that we shouldn't forget that what is draped behind this, you know, TikTok discourse and so on. And look, if you're thinking about, the terms of the discourse, it's something which doesn't make sense at all. Yeah. But behind it, there is a sort of a serious popular dissatisfaction, dissent, which is there. I mean, it's not, something that is created that we imagine and so on. It is there. It's kind of, you feel it, you talk to people. It's just kind of, and a sort of an important distrust and kind of boredom with legality, boredom with things carrying on and carrying on, and yeah. I think now there is a question in the chat, and I kind of try to address that.
yeah, actually, maybe Arsenia can ask the question directly
Yeah.
for the sake of
Yes, and the sake of the record of the archive,
recording.
basically, for the
Right.
sake of the online archive. Okay.
Yeah, so for the records, I just wanted to ask you how it is possible for the Constitutional Court to act so quickly and take important decisions, like canceling the election. We've had similar cases and we're waiting for decisions for weeks and months on end in the Bulgarian case.
I think there were two things. I think on one hand, it was, in a sense, it was fast if you want, but there was a sense that actually that's going to be serious. And I think that there is a level there in which we need to take into consideration that there was a distinction between the parliamentary, the legislative elections and the presidential elections. And I think we need to think a bit about, what are the attributions of each. And the easy answer to that, it would be that basically, look, you have a war at the border, presidential attributions in Romania in a semi-presidential system. They are quite important in terms of defense. And there was popular suspicion and, public opinion saying that this is a sort of, kind of pro-Russian candidate. And then basically that could explain some level of, why it was fast, yeah. I think in a sense it wasn't fast enough, because if you're looking at, that the court had the chance kind of consider itself to be invested by the first, and if you're looking at the first claims that I made, kind of that I was talking about, and they didn't talk about it, yeah, they didn't attach this problem until basically everything was declassified. I mean, all the decisions that were taken by the by the Supreme National Defense Council, until that moment, I mean, they could have said, look, there's something going on. They didn't do it, but they waited for them to be declassified, and they have been declassified by act of the actual of the present president. So I think, in a sense, there are people who would say that actually the court sort of dragged its feet until it was sure of something. Also, there is a sort of a kind of, there isn't a consensus about whether the content of that declassified information is enough to, kind of support such a decision. And then, of course, this is a sort of a factual thing. It's about the act of archiving. I mean, they have the authority to archive something like this. And they say, this is something which exists and it is a threat. We don't have it. Yeah. So as citizen, you don't really have it. I mean, I just hope that they're going to, make the right decision. I don't have really a strong opinion on that. What I can say is that, given the whole, kind of historical, and it's probably for the first time in Romania, in a long period of time, I think it's really the first time in Romania that the public opinion starts to talk openly about the existence of fascism as fascism. So not as populism, not as, kind of, but really to talk about the sort of remnants, historical remnants of fascism in Romania, which, historians, they've been talking on for at least 10 years. I mean, I think it's even more than 10 years. And basically people are asking, how is this possible? Right? Look, I don't want to get too much into that because, we're going to end this conversation this night, at night. But I think really it's not only a fringe subculture. And this is one of the things that I've been telling friends in many areas. And out there, some, people out there, it's not a fringe subculture. It's something which is deeply ingrained in, kind of. And there was a time when you could buy the works of Corneliu Zăracodranu, the leader of the fascist movement. You could buy them in this sort of automat in public, kind of public vending machines, yeah, because we had public vending machines because we are a country of intellectuals, yeah. So you had public vending machines of books, yeah, and you could just, insert coins or, money, and then, you can buy books because, we're such, sophisticated people in Bucharest, yeah. And then basically what you could buy there, you could buy, the works of the fascists from the 1930s, and, look, we have a legislation for all of this. That was dormant. I mean, it was dormant, never, I mean, applied every now and then. Most of the kind of the claims that people were making, and it was who was making the claims. I mean, most of the time it was actually the Institute for the Study of the Holocaust, yeah, basically in Romania. Basically, they were doing this sort of claims, and most of the time they were not, successful because didn't bother. Why should we bother? I think that's another question. And the difference, I don't know what's going on in Bulgaria in terms of what is the constitutional crisis now, because we're just separated by Danube, and we should be actually united by bridges, but it's just separated by Danube, unfortunately. So what's going on in Bulgaria?
Well, that's a really long story, which
okay.
is not directly related to the current lecture. So
okay, that's another story. So if not, it's not. No.
I'll explain you later about that.
Yeah, no, sure. But if it's not something like, because I think, here it was really for the first time that actually what kind of, there was a rise of consciousness in the public opinion that, these things are real. Which of course is not all the public opinion, is not all, it's part of the, people who are engaging in the public life, which is also another problem because I think, there has been, at least during the pandemic, a sort of a operative underground in the social media, basically, kind of, being there constantly, this sort of debates, the virus doesn't exist, it's everything, it's a lie, there is no war in Ukraine, how this is possible that people believe it? Should ask ourselves, how is it possible that things which are, out there, why isn't it at this sort of level of, kind of registering of reality? It's kind of, it's the level of registering reality which is distorted. And, many people are saying that, at least in Romania, that basically it is about the question of, lack of education. But I think, the problem is much more complicated than that. It's a sort of a kind of structural problem of, people being left outside of the public sphere, basically.
So this brings us back to the question of imaginaries and how important they are for not only imagining the shapes and forms of legal phenomena, but also for promoting legal and social legal performance.
Yes, absolutely. Think about, because they have been flooded with other type of imaginaries of crisis. And, sometimes when I'm thinking about it, if you look, it's also the question, the difference at what's going on at the level of internet, yeah, and the level of, existence, kind of socially relevant existence in a sense. It's kind of
also in the times of artificial intelligence.
Yes, absolutely.
That's what Richard Schumann calls digital baroque.
Absolutely.
The proliferation of discourses which create untraceability of reality, because we have a multiverse of realities in all possible senses.
Yes.
And it's not only about disinformation or misinformation, it's about questioning which is the true reality, actually.
Absolutely. That's it.
We have the disappearance of the objective ground for common existence.
Absolutely.
And I'm not saying that as a criticism, as I'm saying that as a matter of fact.
Absolutely. Because the question is, you can, and this is one of the, probably the greatest mysteries that we have to deal with in the future. There is a text by Joseph Raz, yeah? So I'm not a formalist. I'm a critical legal studies person, but, I just like to kind of, move into the formalist, kind of, and to try to, in which basically he says that the basic presupposition of a basic norm in Kelsen, it doesn't mean that that basic norm cannot be multiple. It can have multiple legal orders existing in the same time and the same space, yeah? Theoretically, this is possible. And of course, not only under the conditions of a civil war, yeah, because that's obviously it's possible, by definition. But I think not only under the conditions of a civil war, it's just basically the fact that, we might end up with some forms of pure, strong, hardcore legal pluralism. But, which is very interesting because it's very clear that, some groups already now they are moving in some form of, kind of what was called in 16th century fanaticism. Yeah, fanaticism of that sort of, it comes from fantasticus, it comes from what is, fantasy, the realm of fantasy. But, that realm of fantasy doesn't necessarily mean that it has to stay as a fantasy. Yeah? We know that this is where it starts, kind of constitution starts in imaginary, basically. And it starts at that level in which basically, one of the texts that I've read and I've wrote and I kind of happy and proud to have written is about the fascist movement understanding of themselves and as a group who is detentor or who has at least a legitimate claim as being the detentor of the sovereign power. And they took that position before they, did anything in terms of, kind of gaining power, of actually having it. But they were acting as if they had it. And I think this is something which doesn't necessarily have to do with fascism, or I don't think it has to do anything with what we call radical extremist movements. I think it has to do, and it can have to do with, people who are committed to values of any sorts. And then actually they can say, well, actually we have our own basic norm. We have our own ground. We have our own Grundnorm. Sorry, we believe in it. Challenge me. So
Right.
yeah.
Right. Any further questions or comments? By the
Also,
way,
how Huxley's Brave New World might be relevant for the multiverse of paradigms and informational overload.
that's more a
Hi,
statement, but that I think it's a correct one.
Yes, absolutely. What can we do? What can we do?
Oh, that's the $1 million question, What can we do is a question I renounced several years ago. So what can we understand is even less, ambitious question, but it's also not possible to be answered.
Look, I think my position on this is that it's interesting to kind of be able to try to understand and observe these sort of things. I think it's as long as we can hold that sort of distance or kind of mediation with reality, with grounding in reality, basically, which gives us the grounding in reality, that's it. When that's not going to be possible anymore, we're not going to feel it. So
Right.
what can I say more than this? It's kind of that's what it is. But yeah, I think there are interesting and important constitutional and theoretical questions that can be asked at this moment in time. And I think one of the questions that, I think we had this conversation in Romania in April. It's one of the fact that basically, and that's probably where I would want to kind of stress out before I leave, is this sort of question of that actually constitutional discourse can take many forms. Yeah? It doesn't necessarily have to, kind of be grounded in the state power. The constitutional discourse can be or can take the form of groups of people just thinking constitutionally. And I think thinking constitutionally is not necessarily, fundamentally related to kind of the state as such. It's just the thinking about the state or in state terms. And I think from that moment on, when this is happening, that's already you can think in terms of, kind of having a structure of organization, something like this, and so on and so forth. And I think this is something that we should be aware of. And also, I'm sure that there are grounds for, drawing some sort of boundaries of what does that constitutional thinking mean. But I think we talked a lot about, the unwritten constitution and so on, but it's everywhere. That's why constitutional imaginaries are so important, basically, because they are what connect our images of a future, of being together.
I think that the more traditional constitutional scholars, which are still quite predominant, still believe in this holistic constitutional project, which is entrenched in texture, which is rational, systematic, and logical, and which is monolithic. And I strongly believe, and I try to write a lot about that and teach a lot about that, that the Constitution is actually a narrative-based project, and it's a multitude of narratives. And actually, since the truth is frequently a matter of linguistic negotiation, truth can vary not only from society to society, but also from within the different constitutional subcultures and narratives. And of course, that's create huge epistemic issues.
Absolutely. These are problems, but they shouldn't be afraid of that because
no. In fact, the epistemic complexity of our constitutional reality is the first understanding that complexity is the first step towards stepping into the future, which just became present, I would say.
Things are complicated, you know, that's one of the things. Things
Right.
are complicated. That, I mean, and that's why, you know, it might be the case, and that's another question, that whether, you know, sometimes, and we should probably move away from this idea that the Constitution, well, which is probably unpleasant for many of our colleagues, the fact that actually the constitutional doctrine as such doesn't really hold the power that it imagines it does. Yeah, because all of this, it was about, you know, holding the grips on the forms of formulating the constitutional discourse, and, you know, kind of relegating some parts as saying, you know, they are not constitutionally relevant, or they are not, you know, part of the constitutional discourse and so on, that they were just a form of power of carrying on the doctrinal entity. Yeah, a number of people who are writing the constitutional treatises, who are basically the constitution, yeah, sort of the voice of the constitution. But that has always been questioned, not only by the practice, but also it has always been questioned by, you know, the reality of forms of discursive appropriations of the constitutional wording, or, you know, kind of various forms of the constitutional discourse as such. And, you know, we knew it. I mean, either it came from the left or the right, it doesn't really matter, but there were forms in which basically this discourse has been appropriated. I mean, and it's something which is absolutely fascinating when you see that basically you have movements who, even if they are anti-law, nihilistic, legally nihilistic, and so on and so forth, they would always want to make a declaration, because they want to make a declaration, and therefore, you know, they take the constitutional discourse in their own hands, and then they say, well, you know, we make a declaration of that, you know. I mean, just for me, it has always been fascinating, you know, how actually the communist movement did that all the time, because they were just against the law in many respects, but they had to ground themselves in a sort of a declaration or a decree or a sort of, you know, and then every, you know, kind of movement, it's going to take a form of a declaration of something, which, you know, it's an interesting thing to think of. Good. So,
Okay.
questions, or are we done? Are we done already?
Last
Please, can I
chance for
one question, please?
yes, Vladimir
I'm
Margitin.
sorry about my English. So my question is about Pridnestrovia, Moldovan Republic, and the community there. What we can expect from the future, this part from Europe?
About which
Pridnestrovia,
republic?
Moldovan Republic, Pridnestrovia. Some these
Oh,
countries.
Transnistria.
Yes,
Yes.
exactly.
The Transnistria. Okay.
You see here how the terms are also puzzling, you know, because sometimes you use the one or the other, and they mean different things from the different the same thing from different perspectives.
Yeah. So this one would mean the same thing, but from different perspective, because we're looking at it from yes. Okay. So what's going to happen there? What's going on there? What is the future of that? Oh, look, that part, it all depends of, you know, what's going on, what's going to happen in the future with how the